Please be seated. This is the time set for oral argument in Legacy Education Group versus Arizona State Board for Charter Schools. Our civil number 17-0023. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your time in that regard. We have read the briefs, including the supplemental briefs submitted recently. We've been through the record. We've conferenced the case. We're familiar, I believe, with the underlying facts, procedural history, and the issues before us. So please keep that in mind as you make your arguments here this morning. We're recording these proceedings both by audio and video. The video recording will be available on YouTube in a matter of days after the argument is completed. But since we are recording, as you approach the podium, I would ask that each of you identify yourselves and your client for us. With that, appellant may proceed.
Good morning, Your Honors. May it please the Court, Eric Frazier on behalf of Legacy Education Group and Tucson Preparatory School. Excuse me. I'd like to reserve 5 minutes of my time for rebuttal. Your Honors, the State Board for Charter Schools was required to follow the APA rulemaking process for 3 reasons. First, the legislature has defined what the term rule means in statute, and the frameworks fit that statutory definition. Although the board disputes that the frameworks are rules, and I'll get to that in a moment, the board makes no effort to confront the controlling statutory definition for what a rule is. Second, the legislature and the courts have told us that when agency action fits the definition of a rule, then the agency must follow the APA without further specific legislative action. And third, when an agency promulgates a rule without following that required rulemaking process, then the resulting rule is void and the agency cannot rely on it. Now, the board says that the APA does not apply here.
You're not arguing that the frameworks as adopted and implemented are void and unenforceable, are you?
That the frameworks are void?
Yes.
Yes, we are, because they were not adopted pursuant to the APA. Right. Now, the board says the APA does not apply here, and I'd like to address the 3 main reasons that they give. The first reason that the board gives is that...
Before you get that,
yep.
I have an overarching question that's troubling me is, what relief are you trying to obtain now that the current legislation has passed?
So we're seeking a few different forms of relief. The primary couple are declaratory judgment that the frameworks are...
The frameworks, because there were frameworks that were adopted pursuant to rule, and now we have a legislation that says that they don't have to proceed by the APA, correct?
That's partially correct, Your Honor. I want to take that in 2 parts. First, you said there are frameworks adopted by rule. The rules that were adopted do not adopt the frameworks as required by 15-183R. So if you look at those rules purport to incorporate by reference another document outside the rulemaking process that's called the frameworks. So even the latest rulemaking does not follow the Administrative Procedure Act, and this outside document that the rules incorporate by reference, that document is still void, right? You can't skip the rulemaking process by adopting rules that reference a document processed outside the process.
And the frameworks that were promulgated, I guess we won't use the term adopted, but the frameworks that were promulgated, are they now void after when the legislation becomes effective?
Yes. So the legislation, when it becomes effective, it still does not reach back in time and bless agency action that was taken before that legislation, especially because the new legislation has substantive or procedural requirements that the agency has to follow in promulgating agency action outside the APA. So the new legislation requires the agency to have 2 opportunities for notice and comment from the public, and requires the agency to consider the fiscal impact. but it contains no retroactivity clause, so it does not purport to reach back in time and bless agency action that has already occurred.
Okay.
So we're seeking declaratory relief on that point, getting back to your original question, Your Honor, injunctive relief to prevent the agency from enforcing and relying on these frameworks prospectively. And of course, under the new legislation, the agency can take new action on the frameworks, and as long as it satisfies the new Senate Bill 1055 requirements, it can rely on that new rulemaking exemption after the legislation takes effect, and only if the agency complies with those new requirements in the legislation.
Counsel, I have to confess, I'm a little confused here. My understanding of this record is that there were the board on multiple occasions initiated a rulemaking process as recently as 2016. And those rules went through the APA process, and they've been adopted. Correct?
Yes.
And but you're saying those are unenforceable?
The rules that were adopted are not unenforceable, but there is still an outside document that's outside the rulemaking process, the frameworks.
Well, I guess the bottom line, I suppose, is that issue is not in front of us. We're not going to be dealing with it, but I found your recitation somewhat confusing.
Well, I apologize for the confusion. I think that, Your Honor, that issue is before the court because our complaint asks the court to determine that the frameworks are rules and needed to go through the rulemaking process. The frameworks have not been through the rulemaking process. And so the frameworks, the document called the frameworks that spells out what the board will do when it looks at charter schools, that has not been through the rulemaking process.
I thought your argument was that what they adopted in 2016, pursuant to their rulemaking process, just didn't incorporate everything that was in the frameworks. Did I misunderstand your argument?
So, right, no, you did not misunderstand the argument, Your Honor. And the reason it didn't incorporate everything that's in the frameworks is because it merely refers to the frameworks by reference in the rule. And so if you look at the Goldwater Institute's amicus brief, for example, it explains the problem of what the agency has done, right, where you have a statute that doesn't set forth specific requirements for the agency, and then the agency promulgates rules that give it, that refer to some document outside the rulemaking process. So then we're now 3 steps removed from the legislation. And that's the problem that the APA was designed to address. Just designed to address agencies acting without following the Administrative Procedure Act, without following the process for adopting rules that affect the regulated entities. So our position is that the frameworks that the board has been using for years qualify as rules under the statute and therefore needed to be adopted. That's what our complaint says. That's the relief we're seeking. The agency has followed the frameworks before we filed the complaint. The agency continues to rely on the frameworks, relied on them from the period between when we filed our complaint and the 2016 rulemaking, and even after the 2016 rulemaking, still continues to rely on a document that was adopted outside the rulemaking process. And that document fits the statutory definition of a rule. Now, the board contends that the frameworks are not rules because the statute uses the term frameworks rather than rules, but that violates the controlling statute. And that label is completely irrelevant because the legislature defined what a rule is, and it defined it based on substance, based on the substance of the agency's action, not by the label. That statutory definition for what a rule is would have no application, no meaning, if we just looked at the label of what the agency did or what the statutory label was. The statute tells us to look at the substance of what the agency does. And this court has confirmed that in ASU and Carondelet and Southwest Ambulance. In all of those cases, the controlling statutes did not use the word rule. They used some other word. Yet this court 3 times said the agency has to follow the rulemaking process. The board's second contention is that in 15183R, the legislature did not use or did not expressly invoke the rulemaking process and therefore did not require rules. That, again, conflicts with controlling statutes. The rulemaking requirements under ARS 41-1002 apply to all agencies and all proceedings unless expressly exempted. And again, in Carondelet and ASU and Southwest Ambulance, the statutes there did not expressly invoke the rulemaking requirement. The third contention that the board raises, Your Honor, is that there are different procedures for different sponsors. So I'd like to address that point. That's a complete red herring because both before Senate Bill 1055 and after Senate Bill 1055, the new legislation, the different sponsors that can regulate charter schools have completely different requirements, different procedural requirements for agency action. For example, some regulators, some agencies have to consider the fiscal impacts. Some don't. Some have to provide an opportunity for notice and comment. Some have to provide 2 opportunities for notice and comment. Some don't have to provide any opportunities for notice and comment. Now, that's a little strange, but the unusual nature of this system is the direct consequence of the legislative choice to allow different agencies and completely different types of entities to regulate charter schools. So by design, by legislative design, the different sponsors and the different agencies will have different procedural requirements, and they'll also have different substantive requirements for the charter schools that they regulate. So right now, if you look in the Arizona Administrative Code, Title VII, Chapter 5, there's an entire chapter full of rules that apply only to schools regulated by the state board for charter schools. Those rules don't apply to anybody else. So it's a little unusual, but it's not. That's the direct consequence of the legislative choice to have different agencies regulating charter schools.
When we discuss legislative choice, you're talking about 1055, where it appears the legislature tried to group all 3 together. Did they not?
No. So 1055, first of all, it didn't. It left untouched several other sponsors. So it left untouched universities, public universities like ASU, who can sponsor charter schools. It left untouched school districts. So that Senate Bill 1055 added requirements for the state board for charter schools, but those are different from, for example, the requirements of the Board of Education, of school districts, of community college districts, of public universities. So even after Senate Bill 1055, the legislation does not treat all sponsors the same. They have different procedural requirements for writing rules. Getting back to what we were talking about earlier, Your Honors, this is an important issue, and it remains an important issue even after Senate Bill 1055 and even after the board completed the 2016 rulemaking process. Because it's telling that even under Senate Bill 1055, when the legislature exempted the board from the APA, it nevertheless added in 2 of the most basic rulemaking requirements: opportunity for the public to have notice and an opportunity for comment, and consideration of the fiscal impact so that we don't bankrupt the charter schools. Even now, we know that the legislature does not want the board to write rules without respecting those very basic fundamental principles of good governance. And the Goldwater Institute, again, explained the problem of taking regulatory shortcuts, taking a statute, implementing some rules that leave the agency completely unfettered discretion, and then writing processes that fall completely outside the rulemaking process. We see that at the federal level, at the state level. The courts are the check on that system, and the legislature thought that it was important for the courts to be that check. That's why the legislature gave us a specific statute. It's ARS 41-1034B. ARS 41-1034B. That's the statute that we're here on today, which allows an affected party to come into court and ask that the court declare whether something is a rule. At bottom, this is a question about what happens when the legislature says nothing about rulemaking. Well, it turns out the legislature supplied the default rule, and the default rule is that rulemaking is required unless the legislature says it's not. This court has confirmed that principle again and again in ASU, in Carondelet, in Southwest Ambulance. We ask that you confirm it again today, vacate the judgment, reverse the dismissal, and remand for further proceedings. If there are no other questions, I'd like to reserve the remainder of my time.
Thank you, counsel.
Good morning. May it please the court. Karen Hartman-Tejas on behalf of the Arizona State Board for Charter Schools. This court should affirm the Superior Court's dismissal of the school's complaint for declaratory judgment because the legislature's intent when it amended ARS 15183R in 2012 was that charter school sponsors were not required to adopt the frameworks described in that section by promulgating rules under the Administrative Procedures Act.
Didn't the Senate Bill 1055 pretty much knock the legs under that argument? I mean, if they were exempt from the APA prior to that, then there was really it's not necessary for 1055, is it?
Your Honor, it doesn't knock the legs out of it, or from under it, because the Charter Board does not dispute that it was generally subject to the Administrative Procedure Act rulemaking provisions. Instead, it's because the frameworks requirement applies to all charter school sponsors, and the legislature chose to use the word frameworks instead of rules in Section 15183R. And so it doesn't require APA rulemaking with respect to the frameworks.
Isn't that a bit contrary to the actions that the board has taken over the last several years to institute the rulemaking process repeatedly as it relates to these frameworks?
Your Honor, this court is the sole arbiter as to whether the Charter Board needed to follow the rulemaking process with respect to the frameworks. So it's a pure question of law, and so the sort of factual situation, what the Charter Board has done, does not answer the question.
So we should draw no inference from the fact that the board over the last several years, through its conduct, has signaled its belief that these frameworks are and should be subject to the rulemaking process.
That's correct. This is a sort of pure question of statutory interpretation that rests with the court.
Do you have a comment relative to Mr. Frazier's argument about the rulemaking process from 2016 and his point that in his view that process was flawed because it relied on some document that was not part of the process?
Your Honor, sort of, if we are to assume that the Charter Board was required to follow the rulemaking process, which of course we think that is not the correct.
Well, but you were in the rulemaking process
correct.
in 2016, so
right.
Let's take it from there.
So assuming that the rulemaking process applied, then what the Charter Board did was certainly at least substantially compliant, which is what the statute requires, because the rules that were enacted reference the frameworks. The frameworks were, as required by the statute, public at the time. They were posted on the Charter Board's website. They are sort of replete throughout the rules that were adopted with description of what the frameworks are, how they will be used. So the only thing that sort of was left out there is some of the substance of the frameworks, but those were referenced and publicly available at the time, and all the other requirements of the APA were satisfied with respect to the adoption, which was final in 2017, of the new rules.
Well, if those were adopted pursuant to the APA, are you telling me that the frameworks are then part of the rule so they can't be amended or changed without going through the APA?
Your Honor, one of the rules that were adopted indicates that
one of the rules adopted in 2017.
In 2017,
I just want to make sure that
yes.
I understand what you're.
Yeah. So the rules that were adopted in May of 2017 indicate that the frameworks may be amended in the future. To the extent that the decision of this court is that the frameworks meet the definition of rule and must have been adopted pursuant to the APA, the exemption that will be going into effect later this year would allow them to be amended in the sort of without going through the full APA process. They can provide the necessary notice and comment period and analyze the fiscal impact and adopt them that way, if there are changes to be made to the frameworks.
So the comment period in 20, and I'm sure it's going outside the record, but I'm just curious, the comments that were received in the 2016 rulemaking process, did they reference the frameworks, or were they just referencing the proposed rules that were being promulgated by the board?
Your Honor, the notice of the final notice of proposed rulemaking that includes all of the comments was attached as the appendix to, I believe, our answering brief, and the comments are all set forth there. I'm afraid at this point I cannot give you a firm answer on that, but it's in the record before this court. So there are a number of indications within the text of 15183R that demonstrate the legislative intent was to not require that the charter board comply with the rulemaking provisions of the APA. And the first reason is simply the use of the word framework instead of rule. And that's particularly important here because this is a statute that applies to 6 different entities, only one of which was required at the time to follow the Administrative Procedure Act. When the legislature, the legislation doesn't indicate any intention to treat the charter board different from those other 5 entities. When the legislature wants entities that are not subject to the APA to make rules, it expressly directs them to do so by using the term rule. And at times, it is specifically required that entities that aren't subject to the APA make rules in compliance with the rulemaking provisions of the APA. And of course, the first step in statutory interpretation is always the language of the statute itself. And so I would like to read to you part of ARS 15183R, which states, quote, "In implementing its oversight and administrative responsibilities, the sponsor shall ground its actions in evidence of the charter holder's performance in accordance with the performance framework adopted by the sponsor. The performance framework shall be publicly available and shall be placed on the sponsoring entity's website." So there are 2 key aspects of this language that establish that the legislature did not intend the charter board to adopt the frameworks by following the rulemaking provisions of the APA. And as I stated before, the fact that the word rule does not appear in 15183R, even though in other sections of Title 15 relating to education, the legislature directed the charter board and other charter sponsors to make rules. And second, the legislature didn't stay silent, which is the case in some of the cases that the schools rely on about what the board should do to implement the oversight and administrative responsibilities. It used a special word. It used the word framework. And this court has previously held when the legislature chooses a word other than rule, such in a previous case, the word guideline, the court concluded that rulemaking under the APA was not required, and that's the Duke Energy case. So here, use of the word framework instead of rule is similarly meaningful as it was in Duke Energy, and it demonstrates the legislature's intent that the charter board and other sponsors need not promulgate rules to comply with 15183R.
The choice of the language is a factor. It's not dispositive, is it?
No, Your Honor, it's not dispositive.
And in fact, the cases that Mr. Frazier was talking about, the ASU case, the Southwest Ambulance case, the Carondelet case, all stand for that proposition.
That is true, Your Honor. But there are a few reasons that Duke Energy is the best guide as opposed to those cases. For one, Duke Energy, which was decided by this court in 2008, was the most recent pronouncement at the time this statute was enacted in 2012, and the ASU ASRS case hadn't been decided yet. And the other reason is that the difference between this statute and the fact that it applies to a number of entities that don't have a requirement to promulgate rules in accordance with the APA, as well as one entity that does. Moreover, there are additional indicia that the legislature did not intend any of the charter school sponsors to follow the APA. There's the textual indicia, the fact that they, in 2013, added this requirement that the frameworks be made public. Had they expected the charter school sponsors to follow the APA, that would have been superfluous. And, of course, the canons of statutory construction teach us that the legislature does not enact superfluous legislation.
Of course, that applied to all the entities that sponsor these schools. Most of which are not subject to the APA.
That is correct, Your Honor. But there's nothing within this statute or anywhere else that indicates that the legislature intended the charter board to be treated differently from the other 5 sponsors. And it's important to note that when the legislature wants entities that are not subject to the APA to make rules, it expressly directs them to do so. And that is the sort of, I think, the key difference here between the cases on which the schools rely and this situation. Whereas in those cases, the courts were analyzing a statute that applied to one agency that was subject to the APA when they conducted their analysis. This is a situation where you have a statute that applies to many agencies, only one of which is subject to the APA. Elsewhere in Title 15, the legislature has sort of acknowledged that it needs to expressly direct the agencies not subject to the APA to make rules when it wants to. It has done that with respect to the Board of Regents and the State Board of Education. And in fact, in at least one situation, it has directed the State Board of Education to make rules in compliance with the rulemaking provisions of the APA, and it has not done that here. So, as I mentioned before, the Duke Energy case is really the closest analog to this case. And in that case, the court looked at the fact that the legislature had chosen this word guideline. It had used the word rule elsewhere in the statutes relating to the Department of Revenue in that case. And so it was clear that when the legislature made the choice to use this term guideline, it did not mean rulemaking in compliance with the APA. And this is essentially the situation we have here. So, if the court does not have any further questions, I believe that for the reasons that the legislative intent manifest in ARS 15183R is that the Charter Board did not need to follow the rulemaking procedures of the APA. The board asks this court to affirm the Superior Court's dismissal of the school's complaint.
Counsel, if I may,
Certainly.
I agree with Mr. Frazier's contention that Senate Bill 1055, that you would still have to take some action on these frameworks under that bill, that they're not self-executed just because they passed.
Excuse me. To the extent that this court concludes that the rulemaking requirements needed to be followed, I still don't think that anything further needs to be done, because the adoption of the frameworks as referenced in the rules that were adopted in 2017 was sufficient to substantially comply with the APA. To the extent that the Charter Board wants to change the frameworks in the future, if the determination of the court is that the APA applies to 15183, then they would need to follow the requirements in 1055.
Okay, thank you.
Thank you.
Your Honors, I have a few quick rebuttal points. First, in talking about the remedy, this is up here on a motion to dismiss. So our complaint set forth a valid claim for relief, and the judgment should be reversed. Then when we go back to the Superior Court, we can work on what the appropriate remedy should be to address Judge McMurdy's questions. And I'd like to respond to the discussion you just had about following the new procedures set forth in Senate Bill 1055. Even if the board follows those new procedures, it still would not bless agency action that the board took in reliance on the old frameworks, both before and after the 2016 rulemaking. So our complaint asks for relief on agency action based on the frameworks. So there's still a valid claim for relief, and we can go back to the Superior Court to talk about what that looks like.
Are these agency actions taken with respect to your clients?
Yes.
Or other schools?
Our clients. In addition, we've obviously had a lot of discussion on the 2016 rulemaking, but the board has never contended in its briefing or elsewhere that 2016 rulemaking ends this case, and it just doesn't. So I'd like to discuss a couple of points from the 2016 rulemaking and something that counsel for the board said. You had some discussion about whether the frameworks can be amended outside the rulemaking process, even though the frameworks are now expressly incorporated into the rules. And so if I'm looking at what is new R7-5-404, again, R7-5-404, which talks about the development and use of performance frameworks. This is just one example. And it says the board shall revise the frameworks as needed. During the process of revision, the board shall provide the public with notice and an opportunity to comment on proposed revisions. The board shall adopt revisions at a public meeting. So the board is making up new procedures that it can use to sidestep the full formal APA rulemaking process. That's something that it just has no authority to do. And that's the problem that the amicus brief from the Goldwater Institute addressed, which is an agency putting something in a rule that gives itself more flexibility than it has under the legislation, under the APA, right? You can't just reference something in the rule and then give yourself flexibility to adopt something on the side outside the process. I'd also like to address the notion that the legislature has expressed its intent to treat all sponsors the same. I addressed that before, but I'd like to hit on it again because the legislature still does not treat all sponsors the same, even under the new legislation. So this notion that the legislature wants to have uniform treatment of all the sponsors is demonstrably false. On Duke Energy, Your Honors, that Duke Energy case, the court did not rely solely on the label, as you alluded to, Your Honor. That case did a careful analysis of the statutory text and looked at how the agency was applying the rules. The court emphasized that the guidelines at issue in that case were merely one element in the decision-making process, in the valuation process. But by statute, the State Board for Charter Schools can rely solely on the frameworks in revoking a charter. So that's the problem, that the frameworks at issue here can be the beginning point and the ending point for revoking a charter. That means that even under Duke Energy, they have to go through the rulemaking process. And when you look at Duke Energy in the context of ASU and Carondelet and Southwest Ambulance, it's clearly an outlier. And again, it does not rely solely on the labels, but rather looks at the substance of the agency action. If there are no further questions, Your Honor, we ask that the judgment be reversed, the judgment be vacated, the decision be reversed and remanded to the Superior Court for further proceedings. Thank you.
All right. Thank you, counsel. Thank you both for your arguments here this morning. We'll take this matter under advisement, issue a written decision in due course. With that, we are adjourned. Thank you.